Welcome back to the Constitutional Clarion. This video explains what powers the Commonwealth Constitution gives to the Commonwealth Parliament. The framers of the Constitution were politicians from each of the Australian colonies. In creating a federation, they didn't want a central parliament and government that would dominate those of the states. They envisaged a small central government which only dealt with the things that needed to be done at a national level, with the states continuing to fulfil most of the functions of government. This approach was also important from a practical point of view because to achieve federation, the colonies with smaller populations had to be convinced to join. They were not going to agree to join if they could see that they were going to be dominated from the centre and all their important functions were going to be taken away from them and controlled centrally by federal politicians and bureaucrats. In 1897, a South Australian delegate to the Constitutional Convention, Frederick Holder, said that he wanted a true federation in which each state had its individuality preserved and its independence assured. He saw this as the relevant principle, quote, that in dealing with the Commonwealth, we should confer on it no powers which it cannot exercise more wisely and well and effectively than the states can exercise those powers. I would even go a step further and lay down as the principle which should govern our conduct. To the states, all that is local and relating to one state, to the federal authority, all that is national and interstate. Unquote. Now this largely reflects how powers were allocated to the Commonwealth under the Constitution. Today it would be described as the principle of subsidiarity, that powers should be exercised at the level closest to the people at which they can reasonably and practicably be exercised. The framers of the Constitution adopted an American style of federation which left full power, known as plenary power, to the states and confined the Commonwealth Parliament to legislating only on very specific subjects which are called heads of power. Every time the Commonwealth Parliament enacts a law, its drafters have to ask themselves, is there a head of power, or more than one head of power, that will support this law? At the state level, there's no need to ask that question, as state parliaments, having full legislative power, don't need to identify a head of power, although obviously they can't make laws which would otherwise breach the Commonwealth Constitution. So let's look at the legislative powers that were specifically conferred on the Commonwealth Parliament. Most of them are known as concurrent powers, and that means that a state can legislate about these matters as well. If there's a conflict between a valid Commonwealth law and a state law on a subject, then under section 109 of the Constitution, the Commonwealth law prevails to the extent of that inconsistency. But if the Commonwealth Parliament has not legislated about one of these listed subjects, or has done so in a way that doesn't conflict with a state law, then state laws can fully operate. For example, the Commonwealth Constitution gives the power to the Commonwealth Parliament to legislate about marriage in section 51(21) of the Constitution. But the Commonwealth did not legislate about it for quite a long time, leaving state laws to regulate marriage until 1961, when a Commonwealth law finally took over and displaced the existing state laws. The subjects upon which the Commonwealth Constitution permits the Commonwealth Parliament to legislate fall within the following broad categories that are related to the Commonwealth's international status, its national economic role, matters that cross state borders, or matters which need some kind of national or uniform standards to apply. These are not official categories. I've just identified them myself to group together different powers in a logical way consistent with Holder's description of the purpose of federation. The first category is matters that are international in nature or relate to the outside world. This covers powers to make laws with respect to defence, including the control of railways for defence purposes, external affairs, quarantine, which at the time the Constitution was enacted was largely directed at preventing diseases from coming into Australia, immigration and emigration, naturalisation and aliens, the influx of criminals from overseas, the people of any race for whom it was deemed necessary to make special laws, which again was originally directed at incoming foreign workers, relations with islands of the Pacific, trade and commerce with other countries, and fisheries in waters beyond Australia's territorial limits. In the next category, we have national economic matters. This includes bounties on the production or export of goods, borrowing money on the public credit of the Commonwealth, banking and insurance, other than state banking and state insurance, bankruptcy and insolvency, and foreign trading and financial corporations. The third category deals with cross-border matters within Australia. It covers trade and commerce among the states, the recognition throughout Australia of laws and judicial proceedings, the service and execution of civil and criminal processes and judgments throughout Australia, the acquisition, construction and extension of railways across Australia, and the conciliation and arbitration of interstate industrial disputes. The fourth category is matters that need a uniform standard or approach across the country. This covers postal, telegraphic, telephonic and other like services, lighthouses, lightships, beacons and buoys, astronomical and meteorological observations, census and statistics, currency, coinage and legal tender, bills of exchange and promissory notes, weights and measures, copyrights, patents and trademarks, and marriage and divorce. Finally, we have matters relating to the operation of the national level of government, and this covers taxation by the Commonwealth, compulsory acquisition of property by the Commonwealth, matters referred to the Commonwealth by the states so that the Commonwealth can legislate uniformly on that matter, the exercise of cooperative Commonwealth and State powers, and matters incidental to the Commonwealth's executive and judicial powers, which has also been used as the basis for a nationhood power to deal with inherently national matters such as our flag and our anthem, etc. The hardest subject to put into these above loose categories is that of social welfare. Originally, the Constitution provided for the Commonwealth to legislate with respect to invalid and old age pensions. But this was expanded by a successful referendum in 1946 to include a range of medical and other social security benefits. It could be argued that these fall within the uniform standard category because it's important for all Australians to have access to uniform social security standards, or it could be argued that it's a matter that falls within the Commonwealth's economic role. These powers that I just categorised are the ones that are listed in section 51 of the Constitution. And for fans of that film, The Castle, this is why the lawyer, Dennis Denuto, had to actually learn Roman numerals so that he could refer to them. Specifically, in that case, section 51(31), which was about the compulsory acquisition of property on just terms. But there are other powers conferred on the Commonwealth Parliament by the Constitution. Importantly, there are a small number of exclusive Commonwealth powers that are listed in section 52 of the Constitution, such as the power to make laws with respect to the seat of government and Commonwealth places. But I'll deal with them in another video on another occasion. Various other Commonwealth legislative powers are scattered throughout the Constitution. Chapter 3 contains powers with respect to courts, including powers to create federal courts, section 71, to reduce the age limit for judges below the maximum of 70, section 72, confer and define the jurisdiction of courts, sections 73, 76 and 77, prescribe the number of judges necessary to exercise federal jurisdiction, section 79, limit appeals to the Privy Council, section 74, and confer rights to take legal action against the Commonwealth or a state, section 78. The Commonwealth Parliament may make laws about certain financial matters, including laws about how the Commonwealth's surplus is to be paid to the states under section 94, which doesn't happen anymore, another video about that one day, granting financial assistance to the states under Section 96, taking over state debts under Section 105, and financial agreements under Section 105A. The Commonwealth Parliament also has power under Section 122 of the Constitution to legislate for the government of its territories. This, unusually, gives the Commonwealth a plenary legislative power to legislate for those territories in the same way that a state parliament can legislate with respect to a state. So the Commonwealth can legislate for the territory on subjects which it could not otherwise legislate about because they don't fall within its heads of power. This comes in handy where there's an intergovernmental agreement to achieve a uniform law. The Commonwealth can then pass the agreed law for a territory, and then each of the states can legislate to pick up and adopt that territory law as its own law, creating uniformity across the nation. The Commonwealth Parliament can also legislate to admit new states to the Commonwealth under Section 121 and alter state borders under Section 123, with, however, the consent of the Parliament and the people of the affected states. It could also determine the seat of government under Section 125, which it did when it established the Australian Capital Territory in Canberra. It may pass a constitutional amendment as well under Section 128, but only if it gets the approval of the people in a referendum. There are many provisions in the Constitution which say, until the Parliament otherwise provides. Now, this was to establish initial rules before Parliament was established, but then to allow Parliament to change those laws. For example, before the first Parliament was elected, there needed to be laws about who could vote in the first election. But after Parliament was established, this could then be left to Parliament to determine, which it did in 1902. Section 5136 of the Commonwealth Constitution formally gives the Parliament the power to make laws with respect to all those matters where a provision says, until the Parliament otherwise provides. It's through this power that Parliament can make laws with respect to federal elections, the voting system used, the distribution of seats, the number of senators for each state, the qualification of voters, the qualification of members of Parliament, but critically, not their disqualification, which, as most of us now know, is fixed in Section 44 of the Constitution, disputed elections, the number of ministers, the payment of members of Parliament and ministers, the powers and privileges of the Houses of Parliament, the quorum for sittings of the Houses, the salary for the Governor-General, the appointment of public servants, and the audit laws for the Commonwealth. So all of those things come under Section 5136 because of provisions that say, until the Parliament otherwise provides. Now, all of this describes what subjects the Commonwealth Constitution permits the Commonwealth Parliament to legislate about. But as you've probably realised, the scope of those subjects has been expanded massively by judicial interpretation by the High Court. For example, the external affairs power was interpreted in the Tasmanian Dam case to permit the Commonwealth to make laws that implement treaty obligations. This expanded the Commonwealth's powers to make laws with respect to a huge range of matters dealt with in treaties, including things like human rights and the environment, because Australia has ratified those treaties. So even though you won't see human rights or the environment listed in Section 51 of the Constitution, the Commonwealth Parliament can still legislate about them, at least to the extent that it's giving effect to treaty obligations. And on that point, see my previous video about the external affairs power. Another example is the power to make laws with respect to trading and financial corporations. This has been expanded beyond making laws about how corporations work, such as the obligations of directors and the rights of shareholders, or even the trading and financial activities of those corporations. In the Work Choices case, the High Court held that this power permits laws about the activities, functions, relationships and business of a trading or financial corporation, as well as its rights and privileges, the imposition of obligations upon it, and the regulation of its conduct. As corporations are involved today in most activities in our lives, including things like education and health, this has allowed the Commonwealth to legislate about matters that would otherwise have been outside the scope of its powers. For example, to the extent that universities are classified as trading corporations, and they have been in one case, the Commonwealth can legislate about them, effectively controlling higher education, despite this being well outside the intention of the framers of the Constitution. Often a Commonwealth law will be supported by a patchwork of different powers, each covering little bits of the law and hopefully making a cohesive whole. But as often as not, there are gaps in Commonwealth laws because of the Commonwealth's limited heads of power. For example, if you look at Section 7 A of the Greenhouse and Energy Minimum Standards Act 2012, it says that it applies to the supply of a product whose regulation gives effect to Australia's obligations under certain treaties and international agreements under Section 5129, or where the product is supplied to a foreign trading or financial corporation under Section 5120, or where it was supplied in the course of interstate or overseas trade and commerce under Section 51.1, or where the supply of the product used a postal, telegraphic, telephonic or other like service under Section 51.5, or was a supply by or to a territory under Section 122, or a Commonwealth place under Section 52. These are the types of contortions that the Commonwealth has to go through to ensure that its laws are valid. As for the framers of the Constitution, who intended to create a central parliament and government with limited powers that only did what was necessary to be done at the national level while leaving everything else to strong states, well, their plan utterly failed. Some may celebrate this, seeing it as a consequence of Australia becoming an independent nation and needing a strong central government. Others may regard it as undermining the federal system, creating a costly, bloated and inefficient federal bureaucracy which creates duplication without adding value. Now that's definitely a matter for debate, but in any case it is the system under which we now live, for better or worse. Thank you once again for watching the Constitutional Clarion. I hope this helped you to get a better idea of the powers that are exercisable by the Commonwealth Parliament, and as always, I look forward to seeing you again next time. Goodbye.